All right, we'll be back on the record. This is case number 23-4164. Construction Project Management Unlimited, Inc., Harold L. Samick and Cheryl K. Samick versus Patricia H. Schmidt et al. Mr. Frost,
Your Honor,
how much would you like for rebuttal?
5 minutes, if I could, Your Honor.
Whenever you're ready, sir.
Thank you, Your Honor. May it please the court and counsel. My name is John Frost. I have the privilege of representing Construction Project Management Unlimited, which would be referred to as CPMU, and Harold and Cheryl Samick. I think we need to start with a chronological list of what happened in this case. What happened and what was being challenged in June 18th of 1987. The North Lake Buffalo Shore subdivision was established by Mr. Machado. And in that declaration in the covenants, it gave Class A owners of lots 1 vote, and the declarant, he was the declarant, 3 votes per lot that it was owned. That went on, and then November 30th, 1989, Machado sells to George and Barbara Douglas the 10 lots and declarant rights. That's in a warranty deed and also an agreement. It sets forth the fact they're buying those declarant rights. In August 24th, 1993, George Douglas quitclaims his interest to Barbara Douglas. If you'll see in her deposition, it was that originally he shouldn't have been on the deed anyway because he didn't have any interest in it, she did. But in March 23rd, 1999, Barbara Douglas sells lot 17 to the Samicks by warranty deed. And then in November 1st, 2003, Barbara Douglas conveys to CPMU lots 1, 2, 3, 4, and 19, 5 lots. So at that time, at 5 lots, she had 3 votes for a lot. She had 15 votes. There would only be 14 votes. She would still be the declarant. And that is referenced in the deed to CPMU. And also it's read, it says in the warranty deed, says as successor declarant. And there's also a contract for the sale of the, for the purchase of the declarant's rights, which also references specifically that they are purchasing the rights to take over as declarants. That's in the contract between the Samicks and Barbara Douglas. In February 10th, 2006, there's a 3rd amendment to the declaration, and then March 3rd, 2007, there's a declaration amendment. That's the 2006, 2000 amendments that are referenced here and that are subject to this litigation. In 2006, again, in December of 2006, CPMU conveys lot 12 to the Schmidts, to just Patricia Schmidt. In April 27 of 2007, now this is just after she has purchased the property, she gets a letter from the Samicks, which describes the fact that they have changed the number of votes in the amendment in 2006 and 2007. She reads that letter. She sends in well, they asked to recall certain directors. She signs that, sends it in. So she's read the letter.
Counsel, at that moment, at the time of the 2006 and 2007 amendments, were they allowed to do this? Was
Yes,
the
they
developer
were.
allowed to do it? Does
Under
it
the law.
comply with the Florida statute, specifically 723.075?
Yes, because of the fact that that statute came in effect after.
That whole statute came into effect after
Not the whole.
2006?
They were incorporated under statute 617. That's where they started. And then what's happened then after 617 was 720 that you're talking about came in. And the first time
Wasn't that in 1998, the effective date of that? I don't have the full, I'll just pull it up and double check. What is your understanding of the effective date of 7/20/3075?
7/23, I think it was 7/13. I'm sorry, 2013. I have it, it was added, said 3075 was added 2013.
Okay, you can continue. Lorenzo.
So anyway, that happened, she sends the ballot in. Also, if you'll look in the record, she was asked, and they were specifically asked, both of them in interrogatories, when were you aware of the 2006, 2007, these amendments? And they both answered, it was in April or May of 2007. So they knew about it in 2007. That she signed the recall ballot on May 7th, 2007. On June 2nd, 2007, Smith and Leiter were married. So they were married in June of 2007. So at that time, as married
How would it
individuals-
affect your argument, just in response to that discussion with Judge Brownlee, if that statute had indeed been enacted in 1998?
that part of section 5 of it though, because 5 changed about 3 different times.
We can just start with the beginning, sub 1 of that statutory provision. If you look at sub 2, it says the public policy, which is what I'm asking about, described in subsection 1 prohibits the inclusion or enforcement of such clauses created on or after the effective date of section 3, chapter 98-261 laws of Florida.
And that date is,
Well, I presume it's 98.
well, that was, but one was a statute referring to that statute.
That's what I'm asking you, counsel.
I thought it was 2013.
I guess I'm wondering where you're getting that from.
I'm getting it from, let's see where I.
Are you talking about sub 6? An association may extinguish a discriminatory restriction?
Yeah, I think. Let's see. Okay, yeah. Yeah, but that section.
Which
apply-
section?
The section 17/3075 talks about when the developer transfers it to the homeowners association. This has never happened. It has never been transferred to the homeowners association.
Well, that's your argument, right?
Yeah, it says a developer has the unilateral ability and right to make changes to the homeowner association document after the transaction of the homeowner association. That's after. So that's never occurred. A homeowner association prohibited or restricted from filing a lawsuit against the developer himself.
Are developer rights that run with land?
I'm sorry.
Are developers' rights that run with the land?
Yeah, they're with the covenants in their covenant. That's why they have to be published and that's why they're there and they run with the land.
If I'm gonna convey an interest that runs with the land to you, does it have to be in writing?
Yes, it's gonna be in writing.
So where in that initial quitclaim deed from husband and wife together to wife as a married person, does it reference that real estate right?
It doesn't, and it doesn't have to, because you still have in writing the contract with he is part of that says the rights are declared to.
Who's he?
Okay, let me back up.
Yeah.
When Machado transferred them to the Douglases, there is a written document that says those rights are declared and that's recorded.
Mhm.
Okay, the Douglases still have.
Mhm.
Okay, so that's still there. If he doesn't include it in the transfer to his wife, he still has that document still a record.
I don't understand that.
Well, I can convey an interest that I have in land. I can convey part of it or all of it. So if he didn't convey the clearance rights, then he still has them.
Mhm.
Because there's still a recorded document that if I go look and see, well, Mr. Douglas has those rights. He didn't convey it in his quitclaim deed, so he still has those rights.
But council, wouldn't their response be that he doesn't have any land at that point?
He doesn't have any land.
So he's
But
the
she-
holder of the rights, but he
So-
doesn't have any lots.
Well, then in that situation, what would happen would be then Barbara Douglas would have all the rights. And that's what we're saying. She would have all the rights because he no longer has any land. So if you go back and look at what's recorded in the record, that Barbara Douglas still is a declarant because it's still recorded. Nobody ever took away that. So she would still have the rights, and it even gets easier by the fact that he died. And so if he had any rights, they would have passed to her at his death. But she clearly continued. She never gave up what Machado transferred to her, to Barbara Douglas. It was never given up on the record anywhere until she sold it to the Senate or sold it to CPME. That's when it happened. And so again, if I go check, who am I gonna find as a declarant? I'm gonna find Barbara Douglas. Because if I follow Judge, what you asked, it wasn't in that deed that he transferred those rights. She still has them. So again, where we get back to is
That
taking all
deed,
that-
if that deed that you're talking about, the quitclaim deed, could have been quitclaimed to the Douglas's child, for example, would it have had to have referenced the developer rights?
No, if he's not giving up the developer rights.
If that quitclaim deed would have been to me or any third party, would it have had to represent the developer rights?
If I'm giving them up, yes. If I don't, if I'm not, no.
That last part, I want to hone in on what you said, whether I'm giving them up or not. Isn't the whole point of publicly recorded real estate transactions for everybody to know what rights are running with the land and what's given up and not given up? I mean, it seems like statute of frauds goes back a really long time. So isn't the whole point to explain to the public what's being given and not being given?
So if you do a title search, which you did at this time, let's assume, you're gonna go back and you're gonna find, as it relates to this land, you're gonna find the deed, the recording that says from Machado to the Douglases, it says, this conveyance shall also operate to assign, transfer, or otherwise convey to grantee all rights and obligations of grantor as declarant under the terms of the Declaration of Covenants for conditions and restrictions for North Lake, Buffalo, et cetera, et cetera. That's what you're gonna find. You're not gonna find that was ever taken away, ever changed until it was transferred to CPMU. That's what you'd find on the title search. It's exactly what you'd find. And so at that point, Barbara Douglas owned the rights under this agreement, transferred them to CPMU. And the issue, the big issue, one of the main issues is the statute of limitations. What are you gonna do with it? Because in 2006, 2007, we know the Smiths, we knew that Patricia Smith knew that 2006, 2007, the amendments that you talked about, whether would or wouldn't be valid, were passed and she knew and didn't object to them.
Can Patricia Smith ratify something that is void ab initio?
Yes, she ratified that she knew about
Can
it.
she legally do that?
She legally knew it, and she even answered in her interrogatories. She knew about 2006 and 2007 in April of 2007.
But
So
black
she's-
letter law, can she do it? Can she
Uh.
ratify something that is void ab initio? We recognize her ability to waive or to ratify something that's void.
Well, yes, from the standpoint of if she gets to the next level is, okay, if that was wrong or improper, when the statute of limitations, a 5-year statute ran when those were recorded and she sat on her.
Even
Hey.
if there's a statute that prohibits it, that prohibits this type of declaration, and she signs off on it, does that then make it okay and not prohibited by the Florida statute?
No, what it makes it is that she needs to go ahead and challenge it in the 5-year statute of limitation. She needs to say it's void and challenge it in the 5-year statute.
And if you don't do that, then it sort of erases any efficacy that this statute would have.
Yes, I mean, you can give up by the statute of limitation. I can have a wrongful death case, and that statute says I have a wrongful death case. And if I don't bring it within 2 years, I don't get to bring it. Because the statute says I have 2 years to bring that case. The statute under Harris, and Harris is specific about it, says that you have to bring this case within 5 years of the reporting of the declaration.
Counsel, from your logic, and correct me where I'm wrong, if we were to say that this is void, it would be void from the beginning. And your argument would be that the passage of time could make valid something which was void from the beginning because she didn't exercise her rights to challenge it within whatever statute of limitations we would say applied.
What I'm saying is that the legislature has said, if you have a claim, no matter what that claim is, that you have 5 years to bring that claim. And if you don't bring that claim, then you waive it.
So just for sake of example, so I understand your argument, the statute currently talks about the right of homeowners to display an American flag. Correct?
I'm not familiar with that statute, but
Assume for me it's in there that
Okay.
that a homeowners association can't restrict its residents from flying an American flag. So say for sake of example, there's a developer initiated amendment that says, I don't believe anybody should be able to fly any flags at all, but especially the American flag. 5 years goes by, somebody wants to fly an American flag. Are they stuck?
it depends on when they got the property.
Let's assume it was 5 years and 3 months ago. And that
And
they
they-
signed on to this
And they
proposal.
read it and said it. And
Yeah.
said, "Now, I would think they're stuck because they have the 5. Well, what's the value of a statute of limitation? Because what's happened here during these, now in this case, they didn't file suit till 2018. So in this case, 13 or 15, 14 years have gone by, 15 years have gone by. They've operated and all those things now, we're gonna undo them because they didn't bring it with the statute of limitations. So you've got all 15 years. Now you're gonna go back and look at the books, the records, what all happened during those 15 years. There has to be something in the public policy. To me, the public policy is there's a statute of limitation.
And counsel, that makes sense for like a breach of contract or the negligence action you talked about. But if my defense to a breach of contract was, well, we never had a contract, there's not a statute of limitations on that defense, is there?
Not if we never had a contract.
Isn't that what they're saying? This is void. You could never do this.
But the point is that they're challenging the exact statute. If they said in your case, they would have to allege that there was a contract. You could then defend it if there wasn't a contract. But they would have to have a specific saying that on January 1st, we entered into the following contract. That's what the cause of action would be. In this case, they're saying, look, we waited, we knew about it. And we waited 12 years, 13 years to bring anything. What's the value of the statute of limitations? Because all that has gone on for those 13 years now has to be undone. Has to go back and look at accountings, look at everything else to see what happened. And there's no complaint about how the Samick ran this place. It's all of a sudden we decided 13 years later, even though we knew about this in 2006 and 7, and there's no dispute in the record that they didn't know about it.
You're pretty far into your rebuttal time. Do you want to keep the rest of it?
Well, there's also other issues quickly that we think the court didn't consider other than the statute of limitations. They didn't consider the indispensable party. Basically, what the court did is wipe out the contract between Barbara Douglas and my client, saying they never got the rights, and that was $100,000. And Barbara Douglas was never a party to this. And so
Was indispensable party raised as one of the 19 affirmative defenses?
Yes,
Which one?
which affirmative defense?
Yeah.
I have to look, but indispensable party was one of the defenses. Also, the defenses of latches, waivers, equitable estoppel, were not considered by the court in the summary judgment. You don't see anywhere in there where they even talked about those issues. And we think there were waivers and equitable stoppable and lapses also. So we think that for many reasons, it ought to be reversed and found in our client's favor. The statute of limitations has to mean something.
Sunny,
Hey, please support. My name is Jean Henney and I represent the Appalachia Homeowners Association in this appeal. The appellants are asking this court to enforce two amendments that the legislature has found to be null and void, prohibited, and unenforceable. And they're also asking to reinstate extinguished declarant rights that had been distinguished or extinguished either in 1993, if not then in 1999, and if not then in 2003. We would find that there is no legal basis for any of these requests that the appellants are making. As pointed out, the 2006 amendment, which reinstated declarant rights, there were no declarant rights to reinstate at that point. There was no transfer of the rights pursuant to the 1993 quitclaim deed that were expressed in writing. There was, and more importantly, really, in March of 1999, there wasn't a transfer of rights that was at issue. It was that if Barbara Douglas had somehow still been the declarant, she sold off down to 4 lots that she retained. The governing documents gave her 3 votes per lot, which means that she had 12 votes versus the 15 votes.
Counsel, can you confirm that was the status quo before Ms. Douglas bought back lots 3 and lots 4? It was 12 to 15.
It was 14 to 15, wasn't it?
It was, well, so she sold down to 4 lots, which, and then she bought back. She sold down to 4, which dropped the number and extinguished the declarant right. Because now, then she sold another one, she took her down to 3, and she bought 2 back, which brought her up to 5. Then she sold the 5 to CPMU, which gave that. So they're saying then we sort of, apparently when she bought back the 5, somehow that resurrected the dead, extinguished, no longer in existence declarant right.
And so is this the moment where, when I asked counsel about 723-075, and his response to me was that those rights had never transferred to the homeowners, this is the moment you disagree, and your position is likely your best one is that took place in 1999 when her votes are outnumbered, but it could have also transpired in 1993.
It could have transpired in 1993, in 1999, when her votes were outnumbered, and then in 2003, when she conveyed the property to CPMU. There is no express transfer of the declarant right. So the 3 times, so 2 times there was no express written transfer of the declarant rights, and 1 time there was an extinguishment of the rights via the number of votes had dropped below the threshold level that is required to maintain the declarant rights. So as of 2006, there's no declarant rights and there's no Class B members. So using the declarant rights, they, CPMU and the SAMEX and Barbara Douglas issued this 3rd amendment, and the whereas clauses are kind of telling as to saying we know we don't really have the authority to do this. Like we messed up when we did the 1st amendment, we messed up when we did the 2nd amendment. we, not sure if we had the declarant right, so we brought Ms. Douglas in and she's gonna sign this and she's gonna reinstate them if they weren't there. So all of the whereas clauses say we're gonna just create and recreate something that is no longer in existence.
Counsel, your client brought a deck action in the lower court, and my understanding is that there would likely need to be some triggering event that would require the need for clarity on some ambiguity, some literally declaration of rights, right? Some need for something. What was that need, and was that articulated to the trial court?
Well, so the deck action, there were 4 amended complaints. The
Yes.
very first one was brought in the trial court, in the county court, I'm sorry. And that had to do with a fine, like a $236 assessment that was contested. So we've gotten a long way from $236 here. But that claim was eventually dropped. But what the deck action is continuing violation, a continuing and ongoing claim by the declarants that by BPMU that they're declarants and that they have these rights pursuant to not only the original documents, but pursuant to these amendments. And then there's the ongoing continuous declaration that the amendments are contrary to public policy 723-075. And that statute, not only it limits, the statute prohibits the enforcement. It's not only it prohibits the inclusion or enforcement of certain rights. So when you talk about the American flag, you can't enforce these particular amendments. So it's really a 2-part. It was a 4-count complaint. The first 3 had to do with there is no Class B members. There is no longer a declarant. You can't claim that. And then the 4th count is these 2 amendments that you enacted are void and contrary to public policy as codified by the legislature.
And when is it codified? What's the effective date on this portion? I mean, my understanding is that you're relying on subpart 1 for this argument, correct? Of 723-075 for the void against public policy and then some.
Well, yes, and 1 is 1998. It specifically says that. But we're also relying on subsection 5, which prohibits unreasonable and arbitrary amendments. And that simply codifies, and honestly, I'm not sure when section 5 was added in.
Might be the
But-
2013 amendment.
Yeah, probably, it might have been. So if 5 was added in there, it's really not relevant in terms of the statute when it was enacted, because it was enacted incorporating public policy that was in effect as soon as these homeowners associations were created and enforced. The courts have always said, we will enforce these provisions as contract provisions, but just as contract provisions, you can't put in provisions that are unreasonable and arbitrary. And these amendments where they give one person 19 votes in a 19 lot subdivision is completely unreasonable and contrary to the original idea of the governing documents, which was a transition of the neighborhood. So whether it was 98 or 2013, but both of those sections of the statute prohibit the enforcement, the current present enforcement of those amendments. And then, so they can't enforce those amendments, and you can't claim that you're a declarant and pass new amendments using your declarant rights that are no longer in existence. Pretty much the argument.
Questions? Any questions? All right, thank you. So, Mr. Frost, you have 8 seconds.
Would ask you in response to your question, if you look at Hilton versus Pearson, which says even if the suit alleges that the amendment was void because.
Sir, I wasn't
it was not
joking.
properly enacted.
You're over time. If you want to wrap it up really quickly, go ahead. You have an extra few seconds, but you used all of your time on the front end.
Okay, that's talks about even void, the statute of limitations applies. Even if it wasn't properly enacted or anything, so it's void. Also, I would say that Barbara Douglas still had 5 lots at the time in 1999, so she never gave up the rights.
Thank you. We'll take the case under advisement. We'll be in recess.